Everyone, good afternoon. We're glad that you could join us today for an important webinar on reopening employment law considerations presented by Michael Shadiack, Esquire, partner and chair of the Labor and Employment Practice Group with Connell Foley. I'm Megan Hunter. I'm the president of the Chamber of Commerce. We will be muting you. This is being recorded and will be available after the fact. So we thank Michael for being with us today, and I now turn it over to him for the presentation.
Great. Thank you, Megan. Good afternoon, everybody. Thank you so much for joining us and giving me the opportunity to meet with you today. As Megan said, I am the chair of the Employment Law Practice Group at Connell Foley. And really what we do is we focus on businesses. Our entire practice is focused on supporting businesses. And a big way that we're doing it these days is with their reopening efforts. All the compliance that has to go into it, all the strategy, a lot of questions are obviously coming from that. So Ed and Megan had asked me if I would speak for a few minutes on some practical considerations relative to reopening. Obviously, I also have a very strong interest in your organization. As Megan knows, I chair Roxbury Township's Economic Development Committee and have been doing that for about 19 years. I also co-chair of the Chamber of Commerce's HR committee as well. So I'm very devoted to your organization and all that it offers to businesses. So what I thought we could do today is frame the discussion around a lot of the questions that we've been getting from businesses of late relative to reopening. And I'll go through a presentation and then I'll obviously answer any questions that anyone may have if I could be of assistance. As is typical in something like this, I have to throw up as a first slide a disclaimer, basically saying this is just for informational purposes. It doesn't create any attorney-client privilege between myself and your particular business. Of course, if we can assist any of your businesses going forward, please feel free to reach out to me and we'd be happy to discuss that and see how we could be of assistance. So where I wanted to start, as far as our agenda, is we'll talk about reopening considerations, bringing people back to work. We're going to talk about what we're calling a containment policy, a health screening policy, travel policy, telecommuting policies, and a remote work checklist. And as I mentioned, we can open it up then for questions and answers. So there's been a lot of discussion of late about, well, wait a minute, the stay-at-home order has been lifted. So that means every employer could bring all their employees back, right? 100% staffing. We're hearing that a lot from our clients. That's not true. So Executive Orders 152 and 153 were signed by the governor, I believe it was last week, lifting the stay-at-home order. But what businesses really need to understand is what it lifted was paragraph 2 of Executive Order 107. 107 was the stay-at-home order. And really all that let us do is, as individuals, be free to go out of our house, to go about our daily routine. But paragraphs 10 and 11 of Executive Order 107, which were the ones that pertain to businesses, still remains in effect. Both of those provisions remain in effect. So what it's saying is businesses, nonprofits still have to accommodate their workers with telework, work from home arrangements if practicable, and they're going to remain in effect until further notice is issued and further guidance is provided by the governor. So people say, well, wait a minute, Mike, what about the indoor gathering? The governor said it's limited to 25% of the capacity of the room, but not more than 50 people. So if my business has less than 50 people, why doesn't this apply to me? Because the indoor gathering limitation is only for social gatherings. It doesn't pertain to business. Now you may say, well, how do you know that? How can you be so sure? Well, we have it on very good information. One of my partners used to serve on the legal team with the governor. He joined our firm in late January of this year. So he is still in contact with the chief counsel's office for the governor and asked that specific question of the chief counsel. Do you mean indoor gatherings, that businesses less than 50, we could bring everyone back? And the chief counsel confirmed what I said, which is no, that wasn't the intent. That's only as to social gatherings. Now you may say, so is there any relief available for employers? Well, sure. Under paragraph 11 of Executive Order 107, that provides, okay, to the extent a business has employees that cannot perform their functions via telework or work from home arrangements, the business should make their, and here's the key language, best efforts to reduce staff on site to the minimum number necessary to ensure that essential operations can continue. So what does that mean? As you're planning to reopen, if you have essential personnel that you need to be on site, and you exercise your best efforts to promote social distancing, to make sure it's a safe workplace, you can bring those people back. Maybe you do it on a rotational basis. So maybe you have half your people in 1 week, the next week you rotate, those people aren't working and the other staff come in. But you can do that in order to keep the lights on and the doors open for your business. You're using your best efforts, keep a minimum number of people in the workplace for the essential operations of your business to continue. And I have on the screen here some of the things that the state has identified are those type of workers that you can have on site. And you'll see one of them is administrative staff. So if you have office staff that you want to start bringing back, can you do that? Yes, to maintain your operations, but this is not a free-for-all that we could bring everyone back 100%. We did ask through my contact, through my partner, the governor's office, when they anticipate that all offices will be allowed to reopen. And again, today is June 19th, so as of this date, there is no date certain yet. They're still evaluating that, and they're still coming up with the criteria that they're going to put in place that businesses will have to follow when they reopen at 100% capacity. So we're still waiting for that guidance to come out. So I always think it's important because we're getting a lot of questions about these executive orders. So I wanted to start there as purposes of our discussion. So let's talk about bringing people back. Let's say you furloughed employees. Two different concepts. Furloughing employees versus laying employees off. So if someone was furloughed, what that means is they were on an administrative leave of absence. They're still your employees. They're just on a leave. And then you will expect it to bring them back, and they're expected to come back. A layoff is something completely different. If someone's been laid off, they're terminated. They're no longer your employee. So now they would actually have to reapply, as I'll talk about in just a minute. But let's talk about bringing back your employees that were furloughed. What's the best way to go about that? The best way, from all the guidance that I've read and from my experience, you want to communicate that offer to return to work in writing. You want to provide them advance notice. Maybe some of them are caring for someone who's ill. Maybe someone has childcare needs. Some schools are still open till next week. Maybe they have to plan their daily routine around returning to the workplace. So the best advice, do it in writing, give them advance notice. In that letter, set forth the date they're expected to return, that it will be the same pay and the same work hours. That's important for a couple reasons, as you'll see in just a minute. In my opinion, also confirm in that letter what personal protective equipment you're going to have available for them, what measures you've taken to create as safe a workplace as possible. So think about it. If you're running a business, if you're a manager in a business, you've been very involved this whole time, making sure you're getting ready for reopening. You know what plans you've taken to reopen. You know what safety steps and PPE you have in place. But do your employees know that? They're sitting at home. They're not intimately involved in the reopening planning. So they're probably sitting at home, worried, concerned, have a ton of questions. What is the company doing? What are they not doing? Is it safe for me to go back? Do I feel comfortable? So what we're saying is you can calm those fears. You can calm that anxiety in the letter, making it clear to your employees what steps have been taken by the company to have the necessary PPE in place, or wipes, whatever it may be, gloves, masks, so that they can feel comfortable in their return to the workplace. You also, in our opinion, want to include some language regarding COVID-19 to make sure the employee is not coming back when they have symptoms. So for example, in the letters that we're helping our clients prepare, we would include a paragraph that says something like, we are requiring that all returning workers be free of any symptoms of COVID-19 for a period of 72 hours prior to their return to our facility. The COVID-19 symptoms identified by the CDC include, and then we list them and we all know what they are. If you have any of those symptoms on or after whatever date you're going to put in there, today's date, right, please advise me as soon as possible. In addition, please advise me if you've experienced the onset of any COVID-19 symptom, if you've tested positive at any point, or if someone in your household or with whom you have had close contact has tested positive. So we want to make sure that when these employees return to us, that we've at least asked an appropriate question, that they are not sick and they don't have any of the symptoms. And I think that's responsible action on behalf of the employer. The next thing is you may want to inform them in this return to work letter about your vacation benefits and if you've made any changes to your vacation benefits that you offer. Now, I do want to say with one caveat, if you have any employees who have a contract of employment, and in that contract of employment, you identify or guarantee a certain level of vacation benefits, honor that. That's a contract. Can't tamper with it, can't change it unless you negotiate with that employee. But if your employees don't have a contract, if they're at-will employees and you have an employee handbook, and that employee handbook sets forth your vacation policy. We've been getting a lot of questions from employers saying, Mike, these people have been home now for 4 months. We don't want them when we reopen to take vacation time. We want all hands on deck, number one. And number two, we really don't have the financial wherewithal to start paying people vacation time when they're not producing for us. Is there anything we can do as a business to adjust our vacation schedule? The answer to that is yes. Now remember, this is important. Paid sick leave is controlled by the New Jersey Paid Sick Leave Act. Don't touch the paid sick leave. That's a statutory benefit. It's a statutory right that the employees have. Don't touch it. Don't mess with it. Don't change it. Keep it as it is. As to your vacation policy, you can make adjustments. One very good tip I'll give everyone, look at your handbook. Every handbook, the first page of the handbook should have a disclaimer by law. There needs to be a page-long disclaimer. And typically, one of the sentences you'll see in that disclaimer is that the company reserves the right to amend, suspend, or terminate any company-provided benefit at any time. So you've put your employees on notice with that language that you as management reserve that right to modify, in this case, the vacation benefit. So you may say, I don't understand. What do you mean by modify a vacation benefit? Well, some employers on the extreme end are telling their employees all vacation time is suspended until further notice. Pretty severe, but that's what they're doing. Other employers have said, okay, here's what we'll do. We'll let you use 1 week of your vacation time in the months of July or August, 1 week. The balance of your time, we'll let you use another week between September and December of this year. Whatever you have left, maybe the employer will let the employee carry it over. Maybe they'll cash it out, pay it out. Some employers are taking what's left and adding it to the employee's sick bank for 2021. So there are options. You definitely don't want to take away vacation. That's not going to help employee morale. It's not going to get people motivated to now work for you when you reopen if you're taking something away. But you can modify the way you're granting them the vacation so that it best works for your company. So if you do make those modifications, you may want to include this in the return to work letter as well. We always suggest having a sign-off portion at the bottom of that letter that the employee represents that they received the letter, they read the letter, and they do intend to return to work on the date specified in the letter. Have them sign, date that letter, and return it to you. It's good documentation. Then, the employee's failure to respond to that letter, their refusal to come back to work, well, that can result in their disqualification for employment and even unemployment benefits, as I'll talk about in just a minute. So, returning someone from a furlough, these are some best practices that we advise employers. Now, let's say you laid off the worker. They're no longer your worker, but you want to bring them back. Well, remember, you really should be following your regular hiring protocol.
Unknown caller.
So if you utilize an application, have them complete the employment application. They're a new hire. If you do background checks, conduct a background check. If you issue offer letters, prepare the offer letter for that individual. I-9 form, make sure if they are rehired, you're giving them the I-9 form to complete and submit with the supporting documentation that they're authorized to work in the United States. Okay? Any of the legal requirements, posters, notices, typically you have to put them on your wall in the break room, but then also give a copy to each new hire. Make sure you're giving them that as well. And you say, but wait a minute, they've been my employee. They have these notices. Treat them as a new hire. Give them all those forms again. Give them another copy of your employee handbook. Make them sign off on the handbook. They are essentially new hires. So when deciding which of these people that you laid off do you want to bring back, you really want to consider objective criteria. Essential functions that you need in the workplace, maybe seniority, who's been with you the longest, maybe their skill set and what best fits the needs of the company. But what do you want to avoid? And this is pretty obvious. You want to avoid any discriminatory criteria at all. You make the decision based on someone's age, or their race, or their disability, or the fact that they had COVID-19, or their gender identity or expression. Right? We don't want to make any hiring decisions based on those protected classes, because then we're potentially inviting some type of a claim by the person who didn't get the job, who says, wait a minute, you didn't bring me back, Mr. Employer, Mrs. Employer, because I'm a 70-year-old female, but you brought back the 30-year-old male? Why is that? So you really, as the employer, want to have objective criteria as to who you're bringing back and why. And that's another good reason why, if the job's available, post it and accept applications. Maybe not everyone's going to reapply to come back. So that also gives the employer a level of protection, if you will, because now you're just evaluating the people who did reapply for the job. Okay? Now, many of you may have received a PPP loan from the federal government. And we get this question a lot from employers. Well, wait a minute, Mike, we're making our best efforts to bring someone back. We gave them a letter. It addressed everything you just said, Mike, on those slides. We gave them a letter. And the person just doesn't want to come back. Is that going to impede my company getting forgiveness of its PPP loan because this person's not cooperating and just won't come back? Well, the Federal Small Business Administration answered that question for us, and in a very favorable way. And what they said is, no, that's not what it means. If you've made good efforts, if you set forth a letter, if you detailed everything, and this person just doesn't want to return, it's not going to negatively impact your ability to seek forgiveness of your loan. So that's very good information. Keep that in mind. Now you may say, who actually decides the forgiveness of the loan? It's going to be the lender. Whoever you got the loan through and process it through, if it's your local bank or the bank that you deal with for your business, they're the ones that are going to decide if you're going to get the forgiveness or not. So the more that you can go to that person with documentation, the return to work letter, the employee's refusal to come back, all that is good documentation to help you say, look, we made best efforts to get this person back. They just simply refused. And that should really help your efforts in getting that loan forgiven. Okay, another question we get a lot from employers these days is the employees are just afraid. They're afraid to come back. How do we handle that? Well, here are some items that you should really, I think, consider when addressing that particular employee. And really, there's no one-size-fits-all answer. You really want to do this on a case-by-case basis as to each employee. Number one, find out why. Ask the employee, tell me why you're afraid to come back. The answer may surprise you. The answer may, in your head, say, uh-oh, this person's entitled to certain leave benefits. So we want to know, why are they afraid to come back? And have an open mind and listen to the reason. Now, the person may be afraid to come back simply because they're nervous. As I said earlier, they don't know what steps you've taken to reopen. They don't know what PPE you put in place. They haven't been a part of that planning process. So inform them of the steps you've taken to create a safe workplace. Reassure them that you're doing everything possible to create a safe workplace. Inform them about the PPE that maybe you purchased and put in place. And if you put plexiglass in front, maybe to protect your receptionist or anyone who maybe is an open area, tell them that. Okay? Discuss with them return to work policies that you may have implemented. Okay? Now, if remote work is still an option, maybe explore that as an accommodation with that individual. Now, we've heard a lot about employees who are at a higher risk as determined by the CDC. And I know the temptation may be there to say to that employee, look, you're over the age of 65, or we know you have an underlying health issue. So out of concern, a sincere concern for you, employee, we don't want you returning. Stay home, okay? Or we don't think it's safe for you in this environment to come back. As good or sincere an intention as that may be, don't do that. On June 17th, the EEOC has made clear that we can't ask that question. No matter how sincere you may be, you can't tell someone, because of our concern for your safety, we're keeping you away. Why? The EEOC has said that's discriminatory. We're only taking that decision because of the person's health condition or their age. Both factors, if considered, that would be discriminatory, allegedly. So really the process here is to let the employee come forward. Let the employee tell you, I have an underlying health condition, or due to my age, I have concerns. Okay? Then what the EEOC wants the employer to do is engage in an interactive process with that employee. That means a discussion. You look at their documentation. You get information from their doctor. You see if you're able to accommodate that individual. Maybe remote work is an accommodation. Maybe allowing them to come in when not so many people are in the office, so there's more social distancing. You have to see what works for your organization and for the employee. But that's important. They want us to engage in that discussion with anyone who's at a higher risk. Now, if that employee tells you that they're sick with the virus, they have symptoms of the virus, they're caring for someone, a family member or someone in their home who has the virus, or they don't have childcare accommodations and their school is closed or the childcare provider is unavailable. You have to think about the Family First Coronavirus Response Act, which we're all familiar with, that went into effect April 1st, which applies to every business so long as you have less than 500 employees. So if that employee says, I'm not able to work because of these concerns, okay, remember, they're entitled to 80 hours of paid sick leave under that federal law. So we have to be thinking about that. Another thing, if the employee says, I need to care for a family member, or I need to care for my child because there's no child care available. If your business has 30 or more employees, the New Jersey Family Leave Act applies to your business. Now, some of you may be saying, wait a minute, Mike, I thought that threshold was 50 or more employees. It was up until July 1 of 2019. Then the threshold was lowered to 30 employees. So if you have more than 30 employees, the New Jersey Family Leave Act may be available to grant your employees up to 12 weeks of unpaid leave and continued health benefits during that period of time. The employees have to meet certain eligibility criteria, but that's something management really needs to explore. Talk to your HR professional if you have one, speak with your employment attorney if you have one, because we definitely don't want to violate that employee's rights and deny the leave. Okay? If after exploring all of this with the employee, that employee still refuses to come back to work, you can consider it an abandonment of their job. They're then separated, you move forward and fill their position. Okay? Now, you may say, what if this person refuses to come back to work? Does that jeopardize their unemployment benefits? Well, generally and typically, yes. They would then be forfeiting their unemployment benefits. Two things you really need to know for the employers on this call. Number one, there's something called a BC BOYCAT BC-6 form. That's something the New Jersey Department of Labor has issued. Within 48 hours of any employee telling you they are refusing to come back to work, even though you've made an offer to them, they're suitable work, there's no other reason for them not to be in work, they're just refusing to come back to work, within 48 hours, you're supposed to file a BC-6 form with the state of New Jersey Department of Labor to let the state know you've made a written offer, the person refused, right? When the state gets that, supposedly, they will then turn off the person's unemployment benefits. So if this employee thinks they're being a little slick or they're going to outsmart the system because they're getting sufficient money on unemployment, so why should I return to work? And you file that form, well, potentially the state is supposed to turn off that unemployment switch and not get the benefits any longer. You're also going to get, as an employer, something you're probably very familiar with. It's called a B-187Q form. You may not know it by that coding or that number, but that's the form that comes out and lets you know, here are the people that are collecting unemployment that are hitting your business's experience rating. You get it on a quarterly basis. Review it. If you look at that form and there are people there that you think should not be getting benefits, maybe you made them an offer and they said, we're not coming back. You're supposed to, on the reverse side of that form, within 20 days, include that information and send it back to the Department of Labor. So again, B-187Q form gives you another opportunity to inform who is not returning and inform the New Jersey Department of Labor. Okay. Now, there is an exception that arose on June 11th. The New Jersey Department of Labor said, if this person doesn't want to come back to work, and it's because the person feels the working conditions are unsafe, unhealthful, or dangerous, that's the wording by the Department of Labor, and that's the reason they did not come back to work, then potentially they can still continue to receive unemployment benefits. So what are the things the Department of Labor will look at? I list them on the slide for you. Your company's compliance with OSHA, CDC, other relevant federal agencies' guidelines. Compliance with guidelines from the Department of Labor or the state police. Guidelines as to any particular industry group or association that's specific to your particular industry. The governor's executive orders. And then, sort of like a catch-all, what has the employer done to create a safe workplace? Do you have policies in place? Do you have hand washing stations? Are you providing sanitation and frequent cleaning of high-touch areas? Do you have PPE, masks, gloves available to your employees? Are you following social distancing rules? So the state is going to look at all these things to make a determination. Is the employee still entitled to benefits or not? And that's an exception that I said arose on June 11th of this year. So one of the things I want to chat about are policies. A lot of our clients have approached us and said, can you help us? Can you help us put policies in place for our employees as we are reopening? And the answer to that is yes, and we've been helping with a number of different policies in that regard. And the first one is what we're calling a containment policy. So a containment policy really is intended to prevent or reduce the transmission of COVID-19 in the workplace and to promote a healthy working environment. And there are several key components of such a policy. Number one, we're going to talk about what the employee's responsibilities are for their personal care and hygiene. We're going to remind them and require frequent hand washing, coughing, sneezing etiquette into their elbow, right? Cleaning and disinfecting, what their role is in that process. Do they have to use wipes? Maybe you have a photocopier in a common area, and when someone's done using it, you want them to wipe down the keypad or the buttons, and you have the wipes there for them to do that. That should be in your policy. Okay? If you don't want them to share tools or equipment or their workstation with coworkers without disinfecting it, make that part of your policy. How are you going to contain as best possible the virus in your workplace. So you want to set forth what the employee's obligations are. You want to have another section that deals with the personal protective equipment you have in place. And are you requiring it? Are you recommending it? Or are you permitting it? Now, right now, that's a little bit up in the air until we get clear guidance from the governor. I'm sure when offices are allowed to reopen, I'm pretty confident they're going to set forth requirements that businesses are going to have in place to make sure they're creating a safe workplace. So I think this PPE equipment will be required whenever anyone is in a common area, in a break room, if their sitting area or work area is in the open versus a contained office. I think masks are going to be required 100% of the time. Gloves, well, we'll see if gloves have to be worn. So that would be something as part of your policy as well. Now, as far as the cost, basically, if you're going to require employees to have certain PPE, the employer should be providing it and paying for it. That's the guidance that's coming out as of now. Other parts of a containment policy will deal with social distancing, requiring it. Everyone has to be 6 feet apart, okay? Maybe you're going to stagger work hours or meal periods to promote social distancing, so you don't have 15, 20 people in a lunchroom at one time. Are you configuring your workstations? A lot of our clients are. Are we separating where people sit? Are we maybe staggering, okay, if these two people sit and they face each other all day, can we stagger their work schedules so that they're both not in the office at the same time? Is there somewhere else we can relocate one of those people to promote social distancing? And also you want to limit your in-person meetings to promote social distancing. All this should be done by policy. That's how you're going to control this, but also have documentation as to what your policies and procedures are to best protect your business. How about visitors? That's going to be another part of the policy. Essential business visitors versus non-essential. You may want to take the position that non-essential visitors are not allowed. And you may also want to take the position that anyone who is a visitor to your workplace, you may want to present them with a written visitor health screening questionnaire that would have to be completed. And if that visitor answers yes to any of the questions, such as, have you tested positive? Do you have any of the following symptoms? Do you live with someone who has the virus? If they answer yes to any of those, you're not going to let them in your workplace. So not only does that contain the virus, but think about it from an optics standpoint, from your employee's point of view. That's going to give them another level of comfort that you're taking all these steps necessary to create a safe workplace, including when visitors come to the workplace. How about your delivery, drop-off, and pickup areas? I know in the past, this was kind of loosey-goosey in most places. The delivery person would come in, maybe they even wheel the supplies right into the office, put them in a particular cabinet, or deliver them to a certain department. We don't want that happening anymore. Really, there should be one drop-off point. Maybe that delivery person doesn't even enter your building. They leave the packages at the door and they knock, or they make a phone call and they say, we just left your packages at the back door. Right? Explain that in your policy. And then, of course, there should be a section for the employees to self-monitor their health scenario. If they do have any of the symptoms, having to report it to someone in your organization that you would designate in the policy. Right? Notification requirements as to any symptom or exposure. And then how you're going to administer any leave that may be applicable, the laws may be applicable to your business. So it's a containment policy, and it's one that all of our clients are reaching out and saying, can you help us put something like this in place? Another good idea is a health screening policy. So health screening, the EEOC does permit a health screen when there is a danger to others. And clearly right now, the CDC has confirmed due to the virus, there is a danger to others. So that rationale is met. Okay? You want to make sure that you're implementing any health screening on a non-discriminatory basis. You don't want to just screen people of a certain age or race or religion and not screen the others. If you're going to do a health screening, you do it for everybody, consistently across the board. And then when you get that information, make sure we're maintaining the confidentiality of it. As I'm sure you all know, you need to have 2 files for all your employees, a personnel file and a medical file. So this health screening information would only go in their medical file to the extent that you have any documentation. Okay. Screening environment. So how are you going to do this? Let's say you're going to take temperatures of your employees when they come into the workplace. Well, how are we going to do that? Are we going to promote privacy? Maybe there's a screen that they can walk behind when their temperature is taken. Are we going to do this at the entrance at your facility where everybody can see? How are we going to do this? Are we going to do it off-site? So there are some phone apps being developed. I know one that Microsoft and United Health have put in place and recently released, and I believe it's free. It's called Protect Well. A lot of clients are considering that as an option. Text message surveys. There's a company my firm has learned about and is working with that they're creating for us a survey, health screening survey, that technology is going to be built around it, and it's going to be sent out via a text message to all our employees every morning that they're going to be expected to complete and submit before they come to the workplace. Because if they answer any of those questions in the affirmative, they have the symptoms, they have a fever, they're with someone with the virus, they're not allowed to come into our office space. And it's all done via a text message. So is that how we're going to do health screenings? That's a good option. That's what our firm's going to be doing. Okay. How about social distancing? If you're going to have people line up to take their temperatures as they come into your building, you may want to have tape on the floor or painted lines to make sure that social distancing is maintained. And then who's going to do this screening for you? Are you going to have another employee taking the temperature of the coworkers? Do we want that coworker now having access to confidential health information of their coworker? A lot of our clients are shying away from that. So what they're considering doing is having a third party do the health screening. It may even be some sort of a health professional, maybe an RN, maybe it's a school nurse who, when schools are closed, is looking for employment. So a lot of our clients are looking toward HR kind of staffing companies who are providing this type of personnel to workplaces. And that way you're not dealing with coworkers being privy to confidential medical information of another coworker. Okay? So lab tests, if you are going to require any type of COVID-19 test, please know the employee cannot be charged any cost. That's by law. It really should be picked up, the cost, by your health insurance carrier. If it doesn't, the employer has to pay. The employee cannot be charged anything for any type of employer-mandated test. And as far as antibody testing, very important, on June 17th, the EEOC just came out with brand new guidance. An employer cannot require an antibody test and cannot use the results of that test when determining who to bring back into the workplace. So as much as it may sound like a great idea, it's not a good idea for purposes of your employment law compliance, because the EEOC has said that cannot be done and cannot be used. So here are just some questions you may want to consider when doing a health screening policy. In the interest of time, I'm not going to read them, but I have them here for you on the screen. Okay, so screening results protocol. If the person is negative, enter the workplace. If they're positive, you're going to require that a person to leave the workplace. Maybe you're going to do some contact tracing, find out who they were in contact with for more than 10 minutes. Okay, you're going to clean their work site and have a recovery and return to work plan for that particular person. Maybe they need leave. Maybe they're going to need a doctor's note before they return. But all this should also be spelled out in a health screening policy. Okay, some special issues very quickly. If the person just outright refuses to participate in your health screening questionnaire or protocol, they could be disciplined for that and can be kept out of the workplace. Right? Reasonable accommodations. If someone does test positive, if someone does have an underlying medical issue that can make them vulnerable to the virus, we have to accommodate them, including the 80 hours of paid sick leave under the federal law. Someone may refuse to have their temperature taken due to religious purposes and reasons, that's a very legitimate refusal, something that you should consider and discuss with your counselor or your employment counselor or your HR professional. Okay? And we talked about the other items. A little bit less time on a travel policy. You should have a travel policy in place. Make sure it's uniform as to all your employees. You cannot restrict somebody's personal travel. You cannot tell someone they cannot go somewhere. That's not allowed. You can restrict all business-related travel. So you can say all non-essential business-related travel is suspended until further notice. You could do that. Okay. So some considerations as to limiting business travel. Is it necessary for the employee to perform the essential functions of their job or not? If it's not, the suggestion is, by the government, don't have them travel. Is the only reasonable alternative for completing the essential duties, and you want to consider whether there's electronic communications available. Can we do this over a video conference like we are today, over the telephone? Do they really have to get on a plane or in a car or in a bus or train and go somewhere, maybe another state? If there's a way to accommodate that individual, that really should be considered. And then if any travel is going to be approved, it should be approved in writing by the supervisor. And you want to make sure all these points are in your travel policy. Okay. Protocol for providing notice when that person returns. If they were out of state and they're coming back, you may want to require a 14-day quarantine period. Right? We don't know where they've been. Other states have really created hot pockets of COVID-19. We also know international travel. Other countries are really dealing with the virus and full-blown concerns right now. So if they come back, as a precaution, you may want that person to stay home for 14 days in self-quarantine, and you could certainly require that by way of such a policy that we're discussing. Telecommuting policy. A lot of employers will say, you know what, work from home, but they don't put any policy in place as to the requirements or the details of working from home. And as we all know, the devil's in the detail. So we want to have a policy on telecommuting that's going to require employees to utilize up-to-date antivirus software on their home computer and keep those virus definitions updated. Okay? We want to make sure your company's property is secure. This is your confidential business information. How do we know that what the employee is doing in their house, their computer is safe? So you want to ensure the employee has adequate internet capacity, has the IT equipment they need, has virus software on the computer. If they don't, as the employer, you may want to consider getting it for them and paying the cost of that. Okay? Reserve your right as management to actually conduct a review or an audit of their home system. Make sure it's compatible. This is your confidential business information at risk. So you may want to make sure, maybe have someone in your IT group go to that person's house and make sure everything is up to speed and is secure. Require employees to create and maintain a safe off-site working environment. So think about this. You have your employees working from home. They have a power cord stretching across their room and plugged it into the outlet. That employee while working gets up, they trip and they fall. Potentially, that's a workers' compensation issue because it happened during work time. You say, well, they weren't in my property. Doesn't matter. It's during work time. It's also potentially workers' compensable. So we got to think about that. Okay? You want to set forth in your policy when your employees need to be accessible to answer a phone call, to respond to an email, and how quickly you expect a response. We don't want someone to turn on their computer and they go for a walk in the park and go walk their dog and they're not working and you're expecting an answer. So you want to have parameters as to what you're expecting as far as their response time. Okay? And obviously you want to reserve your right to discontinue this telecommuting arrangement at any time. Now, it may also be feasible for businesses to maintain a written telecommuting work schedule that's tailored to your specific needs or the positional needs. And this may vary. You may want to stagger their work schedule by week, day, or hour and have the other people working from home. This will promote social distancing. Okay? As we mentioned earlier, maybe as an accommodation, you want somebody to work from home. Okay, fine, but make sure you have a telecommuting policy in place that's going to cover a lot of these things. And make clear that for any non-exempt employee, meaning someone entitled to earn overtime, that they cannot work more than 40 hours in a work week unless they have written approval from the supervisor or from a manager. The worst thing that can happen for that business is the employee says, I'm working from home. I'll work 12 hours today. I'll work 14 hours tomorrow. I'll work this weekend, and I'll make myself a lot of overtime. And they have no approval to do it. Right? The employee is going to say, well, you never told me, Mr. or Mrs. Employer, that I couldn't do this. Make it clear. The work week is X number of hours. You cannot work more than 40 hours a week unless you have prior written approval of your manager. And this is a big tip to help you contain any overtime costs. I mentioned the off-site work location safety. I'm a big proponent of having a checklist presented to the employee. I listed some of the things here you may want to consider having in the checklist. In the interest of time, I can't read them all, but they're on the slides for you. Have a written checklist and have the employee sign off that all these things are met and that it is a safe workplace. It's going to help you a lot, especially if there's a claim for an injury that's filed by that employee that occurred during their workday while at home. The fact that you had a written checklist and said, we required these things, the employee read them, signed off, and acknowledged that they were all true, and they created a safe working environment, that's going to go a very long way for you defending any such claim. So at this point, I wanted to open it up for any questions that anyone on the call may have.
Hi, Mike. Great presentation. This is Ed. I've been posting some questions we've gotten from our Facebook Live. They're on the chat. Maybe you can access those. I think there's about 3 questions we have put there. And for those that want to talk to Mike, you can unmute yourself and ask the questions directly to Mike.
Okay, so
there you go.
I'm sorry. Go ahead, Ed. So I'm looking at the questions here listed. So one is from Alan. Hi, Alan. Can I get a copy of the presentation? Of course. Ed, can you coordinate that and email it to everybody on the call?
Yes, and as a matter of fact, this presentation is going to be on our Chamber TV and YouTube channel, and it'll probably be up by tomorrow sometime for sure.
Okay. Next one, I see here a question. What liability is there if someone says I caught COVID-19 at work? Great question. And one I'm not sure I quite have the answer to yet because the law is still developing in that area. Here's the interesting thing. When someone gets ill at work or injured at work, typically the remedy available to them, it's called the exclusivity rule, is workers' compensation. They can't sue you in court, state or federal court. They're going to file for workers' comp and get benefits. Okay. Well, how do you prove that? How do you prove someone caught COVID-19 at your workplace? How do you prove that? What if they got it at the local supermarket or from their neighbor or from their child or from their next door neighbor? How do you know where they got it? So that's going to be very difficult to prove. But here's one thing I want to point out to everyone. If you're an employer that has not been allowed to open yet by the governor, right? Say like me, it's a law firm. We're not allowed to open at full capacity yet. But let's say you say, the heck with that. Who's going to know? Who's going to know? I'm just going to have my people come back. And one of your employees says, I don't feel safe doing that. I don't think the governor has allowed this yet. I don't think I should be there yet. I'm concerned. I think there's still a high risk. And you say, come on, we need you in. Let's go. Come on in. And that person comes into work. Guess what? They get sick. Now, I'm not saying they got sick from your workplace, but they get sick with the virus. That person could potentially, and I underline potentially, right? There's nothing set in stone. But I could foresee counsel, lawyers for employees bringing a claim to say this employer was willfully disobedient of the executive order. They knowingly put this employee at a potential risk of danger when the office could not be officially opened yet. And now that person is going to try to get it out from the workers' comp court and bring a claim into state court and seek additional damages, maybe even emotional distress damages. I foresee those claims coming down as we start reopening and people being forced into work before the governor allows that workplace to open. So just something to keep in mind. I know we all want to get back. I know we all want to reopen our businesses. I understand that, but also realize there's a risk to doing it sooner than we're permitted to, in my humble opinion. Okay. Since New Jersey's opening late, has the forgiveness portion been extended for any PPP loan? My understanding is the federal government has extended the PPP loan program from June 30th through the end of this year. So you can continue to use those monies, and the forgiveness will be determined at the end of 2020. That is my understanding. My suggestion is that you confirm that with your lender based upon the terms of your particular loan. There may have been language in your particular loan that had a cutoff date, so I don't want to give some blanket answer that pertains to every loan that may have been out there, but certainly speak with your lender as to that date. Okay, do we have to pay while someone is on 14 days? Can they get unemployment? Okay, not sure who asked that question. Do we have to pay for the 14 days? Whoever asked that question, can you unmute, and I'd be happy to talk about it. Hello.
Yeah, the question they ask is, you said if it was during the time that you were asking, if you think someone has been in contact because of travel, and you tell them take 14 days, can they qualify for unemployment, or are they paid during those 14 days?
Oh, that's a great, yeah, okay, I got it. Great question. So if you're going to make someone quarantine, and they're quarantining not because they have the symptoms, not because they're caring for someone who's sick, because in that scenario, the Family First Coronavirus Response Act would apply, and they would be paid up to 80 hours at their full rate of pay. Okay. But if they're home quarantining because you're requiring them to quarantine, that's an important consideration for the employer. On the one hand, if the person's not working, they're not working at all, they're doing nothing for work when they're at home, you technically don't have to pay them. Now, in your mind, is that maybe the right thing to do? You're requiring this person to stay home and you're not going to pay them? Some employers have decided, you know what, we'll put them on a paid administrative leave during that time. We just feel that that's the right thing to do. If the employee is working, they're teleworking, they're home, self-quarantining, but they're working, then of course you have to pay them. So there's no rubber stamp answer I can give to that question. I think it is based on the circumstances and your particular policy.
Awesome.
Okay, I think those are some questions I saw here, Ed, in the chat. If there are any others, I'm happy to answer them.
Yeah, I think if anybody has a question, you can unmute yourself and ask Michael your question.
And while we do that, I just want to let everybody know, I know in the registration blurb that the Chamber put out, there was also a link to this. Our firm, our employment group, we put together something we call the Reopening Handbook to serve as a guide for workplaces when they're reopening. It's something that we issued on June 2nd, and it's free, it's complimentary. We're just trying to be helpful to the local businesses. So if you're interested in getting a copy of that, you know, you can certainly click on the link. You can let me know. It goes through our marketing department, and then they will send out by email a complimentary copy. The other thing for additional resources, again, just trying to be helpful. There's no cost. We do alerts for all our clients and contacts on any new employment law, any new case, anything we think employers need to know about, and then they get posted on our website. So if you go to that link there at the bottom of the screen, you'll see all of our employment law alerts we've done for the last several years. But even during this difficult time with COVID, we've posted, I think, 18 different alerts of things employers need to know about. So again, just trying to be helpful to our fellow chamber members and businesses. Maybe we certainly want to take a look at that.